Might as well start. If there's a few late joiners, they can just catch up. And we are recording it anyway, so if you miss something or if you want to go back and watch, you can. Before we get into it, I just wanted to say that the clauses that we're going to go over today, because we did the boilerplate last week. This week we're going to talk about the different clauses that protect yourself and your clients in what we think is the best way possible. But having said that, there might be different versions of the same clause that I'm talking about that you might be using or that you've seen out there. So I'm not necessarily saying that you have to change your clauses if they're similar to these, but there probably will be some clauses that you'll want to change using the example of the title search trap from last week. You may want to look at your title search clause and make sure that it talks about all other non-financial charges being accepted by the buyer. So there's certain ones like that that you do need to change, and they're all mentioned when there's things that are absolutely needed. And if you're not sure about the clause you're using, just let me know. I'm happy to look it over. And having said that, if you see new clauses out there, because I have the benefit of reviewing all of your contracts and all of the contracts that other agents write on your listings, so I see different clauses, and sometimes I think, oh, this is a neat one, and I'll run it by our lawyers first and make sure that it is good. Sometimes they've told me, yeah, it's good. Sometimes they've reworded it. Other times they've told me it's not necessary or it's too vague. And so these are, like I said, just what we're recommending. And just remember that contracts, it's a good idea to do this. And I know you're all experienced agents, but we, myself included, use the same contracts over and over again for years and years without really thinking about why we're using that clause, or has something changed that we shouldn't be using, or do we need to update it. So it's good to look at this every once in a while. And having said that, we will start. And you can still all see the screen, right? Okay. Okay. So goals for today, basically review the essential clauses that should be in all strata contracts. We're going to do detached, and detached in some ways is less cumbersome than strata because there's so many issues with strata we have to deal with, but it depends. You can have zoning and permit issues and new construction. So next week's going to be focused on detached houses, but this is all on strata. Understand why you're using certain clauses and why the way that they're worded matters, like the title clause, and review common situations in addition to the sort of standard clauses for every strata. We're going to review some common situation and where specific clauses are needed to protect your clients, like tenancies and assignments and that sort of thing. All right, so for those of you that printed the contract, you can take it out. Otherwise, I've got screenshots of the different parts of the contracts. And we're just going to go through the clauses sort of one by one and discuss them. Any questions at any time, just unmute yourself and ask. I personally prefer if you unmute and ask verbally than type, but I'll try to watch the comments as well. And again, keep in mind, with all of you being experienced agents, you may think that for example, the financing clause. We're not going to spend a lot of time on that. Other ones we'll spend more time on. So again, just bear with us. If it's seeming like it's something you already know, guarantee you'll learn some new things today. All right, so the financing clause, again, we're not going to spend much time on it. The one thing I do want to point out, and I honestly can't remember where I got this from, it was one of our agents at Remax, I believe, and I think it might have been Brett Skillebeck's, and if it wasn't, then I'll just give him credit anyway. But I highlighted 6 p.m. here, and the reason I did that, and I think I've discussed this with some of you, is after a couple of years in the industry, I wanted to get my life back, and I wanted my spouse not to hate me by taking calls at 7 o'clock at night when we're trying to have dinner. And so by putting 6 p.m. for your subject removal, and it can be 7 p.m., 8 p.m., 5 p.m., it doesn't matter, but by putting a time, you are basically making sure that if subjects are going to get removed on that Friday night, it'll happen by 6 p.m., then you can have your night to celebrate or have dinner with your spouse or watch a movie without feeling like you can't have a life, because otherwise it's till midnight. And just from my experience, buyer's agents will often take, or whoever, your buyers rather, will often take till midnight, 11:59 before they remove the last subject, even though they got their financing approved at 3 p.m. So it just sort of forces them to deal with it or not. So I recommend that, but again, you have to do it on all of your subjects, because if you forget to do it on one of them, then it's open till midnight anyway. So that's all I really wanted to say about that. There is and I've seen some of you use it, there is I think actually Sam uses it, the actual one from web forms, and he fills in all of the terms like subject to a new first mortgage being made available by at a interest rate not to exceed this, at blended payments of this. So it's actually the preferred one. That's what you should be using. But I think most people don't use it because you do have to do all those calculations. And thank you, Sam, for doing those calculations. But I've also seen people use it where they leave all the blanks there, and you cannot do that. So if you're going to use that clause, you do have to do the calculations. If you don't want to, then go ahead and use this. There was a bit of worry with using this type of a subject to the buyer finding suitable financing for it being a little bit vague to be enforceable. But again, with the seller's acceptance is irrevocable, we discussed that last week. That means that once the seller accepts it, they can't come back and say that this clause, for example, is too ambiguous and renders it void. They've accepted it. So you can use this without worrying about it being too subjective, but it's up to you. And I'll also mention, by the way, when something is a stillhaven clause or a custom clause versus a standard web forms clause. So the inspection one is actually part web forms and then modified. And the reason it's modified is because it's strata. So again, we have the 6 p.m. And then at their expense, receiving a site inspection report against the defects whose cumulative cost for exceeds. And you could put any amount you want in here. The reason I like to have an amount as a listing agent and as a buyer's agent is it prevents the buyers or the buyer's agent from asking you to fix every little, broken picture hook or every little chipped light plate on the wall. So if they come back to you and they say that they want this, and this done, and the total is like $80, you can basically say, well, that's not what the contract says. So as a listing agent, I like it because I can push back on the buyer's agent when they ask for those petty things to be done. And as a buyer's agent, I like it because then I have a reason to not seem petty to the listing agent by asking for all those silly things to be repaired. And I just tell the buyer, look, this is normal. You're not buying a brand new home, and you can put whatever amount you want in there. So that's why I recommend that. And then this one is important for condos, I've found, because oftentimes, in my experience, when I was selling a lot of condos in the West End, is the listing agents, if they were lazy, wouldn't bother getting the access to the common areas. So the seller will allow and arrange for access to the property and any common areas, including but not limited to the roof, electrical, boiler, elevator, parking, storage, rec room, and all that. And then this subject is for the sole benefit of the buyer. We talked about why that was important last week. With this clause added, of course, it doesn't guarantee that they'll get it, but it reminds them it's in the contract. And then I would remind them, as it's getting close to inspection, we need access to all of this. And I know some of you might say, well, you can't access the roof hardly at all anymore, which is true. But in some buildings you can. So by putting it here, we get access, hopefully, and if not, it's not a big deal. Elevator room access provided to anyone but licensed elevator techs. So I'm not sure, Sam, if that's new or because I used to get access to elevator rooms all the time, or maybe it's building specific. But yeah, by asking for it, it's great. And if it is a new rule, then we might just modify this clause. But I think it's more building specific. Okay. And then this strata document clause is again a hybrid of the web forms one, and we've talked about it, I think, at one of our meetings. So the highlighted yellow parts are the ones that are different from what's on web forms. So a current no older than 30 days Form B. And I know I've seen some people put 60 days. The contracts I'm looking at most of the time are silent on it, so you could get a 3 or 4 month old Form B depending on how long it's been listed. The issue is your buyer's lawyer is going to request a new Form B that's less than 30 days old, and your buyer will have to pay for it. So I've never really had any pushback on this. I think on a lot of times the listing agents don't even read it, but it forces them to give you the new Form B rather than your buyer paying for it. You can decide if you like that or not, but that's what we recommend. The rest of it is obviously the standard things, and then the yellow highlighted parts at the bottom. So a copy of or access to any engineer's report or building envelope study performed on the property. I wouldn't mind hearing from some of you guys that sell a lot of condos. Again, when I was selling condos, it is leaky condos was kind of a big issue at the time, and it remained a big issue for most of the time that I was selling full time. Nowadays, I'm thinking that a lot of those buildings, if not all of them, most of them have been remediated, and new buildings don't really require it. Are you seeing a lot of new engineering reports out there on buildings, or is it still you're looking at ones from 2005 or something? If anyone wants to comment, I'm just curious.
I'll say, Steve, most of the newer buildings have warranty reviews instead of the engineer's reports or depreciation reports.
Okay.
So you've got like the 5-year warranty or the 10-year warranty, which I think is being more commonly used than the older engineer's reports, and then the depreciation reports.
But the warranty reviews are usually done by engineers, aren't they?
Yeah.
Okay, but it's a good idea. So I'll modify that clause in our web forms to just include warranty reviews. That's great, thanks. I was just curious about that.
Steve, one thing that I have in my strata documents is subject to the buyer on or before blah, blah, or 48 hours after receiving all documents for the strata docs. Cause I had
I've got that coming.
Okay.
Yep. And then a copy or access to any depreciation report. For some reason, I don't know why that's not in the web forms version, but it isn't, unless they've changed it recently. And then copies of the Strata Corporation insurance policy or policies, or a summary of coverage, a coverage note, or a binder in respect of the same. That's the same language from the Strata insurance clause that was sent out recently, except I'm putting it in with all the other Strata docs that I'm requesting, so I don't have to ask for it in a separate clause, and you'll see that in a second. And then what Doug was referring to, so immediately upon acceptance of this offer or counteroffer, the seller will authorize the seller's agent to request at the seller's expense complete copies of the documents listed above from the Strata Corporation or other source, and to immediately upon receipt, this is where it changes, and in any event not later than 3 business days after acceptance, deliver the documents to the buyer or the buyer's agent. Buyer and seller agree that in the event that any of the above noted documents are not received by the buyer in the time frame outlined above, so 3 days, subject removal period for all subjects shall automatically be extended to 3 business days after receipt of the final outstanding document. And what Doug's referring to, I think, is one I've seen in a Sutton subject clause addendum that they have. So I've seen different versions of this where it says 48 hours. The wording on the Sutton one seemed a little bit confusing to me, so that's why I didn't change it. This was given to me by Richard Bell from Bell Alliance years ago, and I vetted it with him to make sure that it was legally binding, and it is. So it does extend the subject removal. They can argue all they want, but it is extended automatically. And again, most listing agents I don't think are even reading this, so sometimes they're at a bit of a surprise when you tell them about it. So any questions on that? Because the thing I'm seeing is that a lot of people aren't using that, and it's been a lifesaver for many agents at my old Remax office. So I highly recommend using that. And the only other thing I wanted to mention here is at the top, and there's other subject clauses like this where it says the seller/buyer will authorize the seller/buyer's agent to request. And I see so many agents, even experienced agents, because I've seen it in some of your contracts out there, that you don't change that. You just leave it. It's like not changing the financing subject. So please make sure to read these things. And if you want the seller to pay for it, which is normal, then you erase the buyer part. So don't leave those items in brackets are meant to be modified, not left the way that they are. All right, Strata insurance. So this is the second part of the Strata insurance clause that came out. So again, I'm not requesting the documents here because I requested them in the previous clause. And now I'm just saying it's subject to the buyer reviewing and approving the terms of the Strata Corporation's insurance, including premiums, blah, blah, blah. And then B, the buyer confirming the buyer's ability to obtain personal Strata owner insurance on terms satisfactory to the buyer, including coverage as per the portions of deductible, blah, blah, blah. This benefit subject to the sole benefit of the buyer. So rather than put it as a separate entire clause with the documents, I just modified it. You don't have to do that. I just thought it was tidier. The PDS clause is straight from web forms, so you can go ahead and use that one. The one thing I will say, I see a ton of people not putting the date that it was signed, and you should be able to get that from the listing agent. Fill it in later if you have to, but it really should not, there should be no blanks in a contract, right? So just make sure that that's filled in later if you can't do it right away. And then of course, if approved, such statement will be incorporated into and form part of this contract. And then tenancy agreement in this example. So this isn't going to be in all of your clauses, but I wanted to do a tenancy example in this sample so that we can talk about certain things that are required. So it's subject to the buyer receiving and approving the current residential tenancy agreement for the downstairs tenancy. This is an example of a sort of there's a separate suite, even though it is still Strata. So just keep that in mind. It's just an example, but I wanted to make sure that we had some different situations in there. And so you just want to take a look at the tenancy agreement essentially. Okay, and then this is what the original one from web forms looks like for the Strata insurance. So it's the same clause that is the subject, but then it says immediately upon delivery of this contract, all parties, the seller or the seller's agent will obtain copies of the Strata Corporation, blah, blah, blah. So we've already included that in our previous Strata Docs clause. But again, if you're not doing that in your Strata Docs clause, then you should use this because it's asking for those documents. Make sense? All right, terms and conditions again. So title search. So we talked about the section 9 title trap last week. So this is all I wanted to highlight here is just that your title clause has to have this wording in order for your buyer to not potentially have the ability to force the seller to remove something he can't remove, like a right of way that isn't specified in section 9 of the standard contract. So the buyer acknowledges and accepts, despite any other provisions in this contract, meaning section 9, that upon completion, the buyer will receive title containing any non-financial charge set out in the copy of the title search results that is attached to and forms part of this contract. So again, make sure that's any of the title clause that you're using. Parking and storage, this is completely separate. And again, I've ran it by Bell Alliance because when the Form Bs first came out, I'm hoping it's better now, and one of you guys can comment on that, but when the Form Bs first started being used, and I know I'm dating myself here, but when they were first being used, there was a lot of strata corporations that just didn't bother filling it out. They just said not available, we don't know, talk to the owner, something like that. And so subject to the buyer receiving from the seller written confirmation, which is the Form B, of the parking stall and storage as to whether it is designated as limited common property under lease, or license or otherwise. If this information is not contained in the Form B, so 99% of the time, hopefully, or 90% of the time, it will be in the Form B. So then this second part doesn't kick in. But if it's not in the Form B, then a letter is to be provided by the property management company or the strata council for the above information on or before 6 p.m. April 21st. If such arrangement is by way of transferable lease, the lease shall be transferred to the buyer at no cost to the buyer. So the reason for that, in case anyone doesn't know, is because the only people that can confirm the parking or the storage is the strata corporation or the property management company. So having the seller warrant that parking 25 and storage locker 25 are included doesn't really help you, because if they don't, if it's wrong, let's say there is no storage locker, or it's the wrong storage locker and it's smaller, or it's a smaller parking lot, parking stall, then you end up having a situation where you have to now sue the seller for the smaller space, or you're having them warrant something and then they've left the country or they've sold, and then you have to take it to small claims court or court. It just is not helpful. Generally speaking, warrant only goes so far. So it's not strong enough for parking and storage, and parking and storage are by far where most strata litigation occurs. And so we really need to be careful with it. So I highly recommend you use this. Worst case scenario, because this has happened as well, is they simply say, property management company will not give me a letter, strata corporation council will not give me a letter. And then you're no worse off than you were by saying that the seller warrants it. So you still have the same information. Hopefully the seller's told you, look, it's parking stall 25, it's storage locker 25. I'm not able to get anything in writing. Mr. Buyer, make your decision, decide what you want to do. But oftentimes you will be able to get a letter, and it gives you some more security. So again, that's why I recommend that clause. So the seller agrees to provide complete copies, this is straight from web forms, of all notices and meetings from subject removal date to completion date to the buyer and the buyer's agent within 3 days received from counsel or the property management company. Sorry, I actually misspoke. This is not in web forms. We just recommend that you do this so that your client's able to keep up with what's going on in the strata between subject removal and completion. The special levy one is, again, a bit of a hybrid, and I'm seeing different versions of it out there. But essentially, if it's approved prior to completion date, the seller will credit the buyer with 100% of the special levy that the buyer is obligated to pay under the Strata Property Act, and the seller hereby directs the buyer's lawyer and notary to hold back such credit from the sale proceeds and remit it to the Strata Corporation. This is the important part, and it doesn't happen often anymore, but it still does happen in some older stratas I've seen. If a special levy is due in installments, and the special resolution authorizing the special levy does not make any requirement for the seller to pay the outstanding balance before conveying the strata lot, often it will say that, but if it doesn't say that, then the seller agrees to pay the entire amount of the levy owing on completion date. And if it's been proposed in a resolution, so let me talk about that part first. So if a special levy is approved prior to completion date, the seller has to pay it. It's as simple as that. Sometimes stratas will make it, for convenience, to make it more affordable, they'll make it payable over 12 months, let's say. When they do that, often they'll say that if the seller if someone sells their lot, they have to pay, the entire amount is now due and payable, and they have to pay that off. But if it doesn't say that, if it's something that, let's say, for example, every 6 months there's a $500 levy so that they can save money for power washing, whatever. In that case, if it doesn't specify, then your buyer will be on the hook for all those $500 payments after completion. Even though it's already been approved, the payments aren't due until after completion. So that's why you want this in there, because it just protects your buyer from any special levies that are passed, regardless of if it's in installments or not. Then the next one, which is not in web forms at all, but I highly recommend it, is if a special levy has been proposed in a resolution which, together with a notice of an annual special or general meeting, is delivered to the seller in accordance with the Strata Property Act, prior to completion date, the buyer's lawyer may hold back the amount of the special levy, blah, blah, blah. That's important because, well, the way it's worded is important. So I see a lot of special levies, like if it's been proposed, then, you know, if a special levy is proposed, there's a holdback. Well, what's a proposal? That they're talking about changing the carpets in a year, or that they're talking about redoing the roof, and then you end up with people interpreting it differently. The only way a real proposal can be done for a special levy is in an annual, special, or general meeting. So by specifying that, hopefully as a buyer's agent, if you get any pushback from the listing agent, you can explain that to them and they'll be comfortable with it. Worst case scenario, they cross it out and your buyer has to make a decision. You do have some sellers and listing agents, some of you may be this way as well, that you just automatically don't like that and you cross it out, which is fine, but putting it there doesn't hurt. Sorry, I'm just seeing some notes here. We have all subjects due by 6 p.m. for first thing before clauses, not an individual clauses, saves time. Is there an issue with that? No, I've seen all of your team ones, and I've seen a bunch of other people that have one sentence at the top. Yulia is basically asking, do they all have to be separate? That's just what I've done, and it's just habit. There's no requirement to do it. Yeah, so that's what Ben is saying. So the following subject of the sole benefit for the buyer must move. So that's fine if you want to do that. I've seen in some cases, and not with you guys, hopefully because you're experienced, but I have seen in some cases when you do that, sometimes a subject gets missed. And so I'm just be careful of missing subjects when you're copying and pasting, because you have them sort of all together after that one sentence. But yes, it's totally fine if you want to do that. You just have to make it clear. Okay, so that's it for subjects. And you all know hopefully the difference between subjects and terms. So the seller warrants that all appliances, electrical and mechanical within this trial. This is not from web forms, unfortunately. I think it should be, so it should be in all your contracts. Essentially, you just want to make sure that, you know, let's say that your home inspector didn't test the burners on the stove. This clause is going to make sure that the seller has to be responsible to pay for the repair of that third burner that doesn't work. And by adding appliances, electrical and mechanical, it covers pretty much everything in a strata lot. It has to be in good working order on possession. The second part I liked, I saw that in someone's contract, that the seller warrants that the appliances included in the purchase price will be the same as those viewed by the buyer on April 15th, 2020. And I think it was Ben that was telling me they take a picture, I believe, maybe he can confirm, they take a picture of the appliances on the day that they view it or at some point when they're there, so that they have some physical evidence. So I like that idea as well, but having it in the contract also is a good idea. And the reason I highlighted these is because these are terms, you know, the buyer is warranting this, the seller is warranting that, the seller will deliver. So the next one, the buyer acknowledges and agrees that while included items will be in substantially the same condition on possession as when viewed, they are not new and as such are not guaranteed or warranted by the seller. The seller agrees to provide all manuals, instructions, and warranty information if available. So that's, in a way, it's similar to the inspection not being over $1,000 worth of repairs, because it's just making sure that your buyer is aware when you write the contract, but also aware if there's an issue, you can remind them, look, you bought a 10-year-old home, so the items included are 10 years old. They're not going to be perfect. And so it just, again, covers yourself a little bit.
It stops you from having to buy your buyers
Yes, it does.
a new microwave.
Yes, exactly. So that's a good point. And some of these clauses are obviously not to protect your client as much as to make your client understand certain things and just be on the same page and realistic expectations, essentially. Does this clause contradict the clause before? Which clause, Rob? Maybe you want to unmute and ask?
Yeah, just one says warrants will be in, the one before says the seller warrants that all appliances will be in good working order.
Good working order, but that doesn't mean perfect. And so this is just that will be in the same condition on possession as when viewed, right? So let's say, for example, you didn't have the one before. So if you had just this one and it says that they'll be in substantially the same condition on possession as when viewed, let's say your inspector didn't test the stove or you didn't have an inspection. Well, the third burner didn't work when viewed and it doesn't work on possession. The previous clause will ensure that it should work on possession. Because even though it didn't work when viewed, all appliances have to be in good working order. Does that make sense?
Yeah, I guess so. So the second one says that they are not new and not guaranteed or warranted by the seller. But then the one before that says that they have to be in good working order. So, like,
well, they're not. I ran this by lawyers. It's not contradicting. It's adding to. Because you're saying, look, they're not guaranteed, but they do have to be working. So they're working on possession. They could break the next day. They're 10 years old. Right? So the seller will deliver the premises, and I've seen a lot of people use this. The premise is fresh and clean and free of all possessions except those stipulated in section 7, which is the included items part. So it's just a little clearer about what they're allowed to leave behind. The seller will, or should leave behind, the seller will provide a copy of the cleaning receipt if requested by the buyer or the buyer's agent. I like this. I've seen a lot of people add it, so I thought it was a good one. The seller will remove all garbage and debris from the interior and exterior of the subject property. In strata, it could be a townhouse, as well as the designated storage locker and parking stall if applicable. So just so everyone's on the same page, take your junk with you, leave the stuff you're supposed to leave. So again, it's just a warrant. One thing I did want to discuss with all these seller warrants, buyer acknowledges, seller will deliver, because we've had a couple of unrepresented deals happen, and we discussed a little bit of that yesterday. In an unrepresented situation, when you're obviously representing the seller and you are not representing the buyer, please be careful about these clauses. Why on earth would you have the seller warrants anything, the seller will deliver anything when you're not representing the buyer? Those clearly benefit only the buyer. They don't benefit your seller. Why make your seller spend money on professional cleaning if the buyer doesn't specifically request it? This is being written from the point of view of you representing the buyer, so you are looking after their best interests, but you wouldn't put anything like that in an unrepresented contract unless the buyer specifically requests it. So I just want to make sure that everyone's on the same page with that.
I have a quick question, just going back to the middle one.
Yep.
You said that you had a lawyer write it. I was just wondering, is it possible to add just they are not new and such are not guaranteed or warranted by the seller past the possession date?
You can modify anything you want. I don't think that's necessarily a bad idea, but it's sort of implied. But if you want to make it crystal clear, sure, you could add that. Yeah. Christy holds. I also had the seller warns that there is no hidden damages, stains, holes under any rugs, furniture, chattels. That's actually not a bad idea, and I may add it actually to the. I'd forgotten about this one issue that happened at our office about 4 years ago. It's pretty funny actually. So beautiful hardwood in like the main living area of the house. Beautiful brand new hardwood everywhere, and a nice area rug. And to save money, the owners didn't put hardwood under the area rug because they knew the area rug was always going to be there. They had plywood. So it was essentially a square of gorgeous, real hardwood, all polished and everything, and then plywood under the area rug. And of course, when the owners took the area rug and the buyers moved in, they were mortified and tried to take them to task. I honestly don't know if they ever took them to court, but the information I was given from Richard Bell, because don't forget, BC is very much a buyer beware province. And so essentially, I think, and this was Richard's opinion, was that you're not going to go far with that at all, because all you had to do was lift up the rug. Now, would most people lift up the rug? No. But that it's not a material latent defect because it's easily discoverable. You lift up the rug. Was this this is Karen saying I do that, Christy. I had issues before. So yeah, that's actually not a bad one to put, because it puts the seller on notice that we're asking you, and they would have to lie by not telling you in that case. So I'll make a note of that because I think that's actually a good one, Christy. Next, the buyer is aware that the Strata Corporation charges an additional monthly fee of. The only reason for that one, to be honest, is if you're working especially with newer buyers and they can afford their mortgage. And I know the mortgage brokers add the strata fees into it for their affording it. But I think sometimes the strata fees are becoming higher and higher. And it's just a good idea for the buyer to acknowledge that there is another $500 a month fee. It's more of a cover your ass thing. Does anyone know what would happen? Because we've had this situation happen a couple of times. What would happen if, so right now in this one, it says that it includes hot water, gas management. And of course, you're putting that because that's what it says in the listing. What if you find out after closing that gas isn't included and your buyer starts getting a gas bill? Anyone had that happen to them or know what would happen? Chirp, chirp.
But I'm still dealing with it. I'm trying to.
Oh, that's right. You did have this happen. Yeah.
Yeah, I'm trying to get the seller to pay for gas costs for probably the next few years. So we're just negotiating on it right now.
Perfect. Okay, good. And yeah, so the situation that Ayla had, and I know there's a couple of agents that had it, is it's just a mistake. And usually this happens, again, why you're not supposed to copy information from old listings. That's usually why it happens. You're copying information from an old listing or from other listings in the building. So the buyer would have to prove in court that that was a material aspect that had they known gas was not included, they would not have bought it. and the amount is so marginal that they would have a hard time ever proving that. So what Ale is doing is exactly what you would do, is you would just try to get your buyer whatever you can from them. It's usually not worth going to court over, and you certainly couldn't claim that you wouldn't have bought it in court. They would never buy that. So the buyer understands that the use of the subject property is restricted or prohibited by the Strata Corporation with respect to pets and rentals. That's just an example, whatever it is. The reason I recommend that, and I actually had it happen to me, I forget the address, but it's on Barclay, I believe. Soraya probably knows the building, but anyway, everyone in the building has 2 pets, but there's only 1 pet allowed according to the bylaws. And so when I was selling one of the listings there was a lady that wanted to buy it, and I wasn't representing her. And she told me she had 2 dogs. And I said, well, I know a lot of people in the building have 2 dogs. They don't seem to care, but you know, this is what it is. And so when the offer came in, I made sure that I added this clause because I wanted to make sure that they acknowledged in writing that they knew about that pet restriction. So that's why you have it, and it's really to cover yourself. And same thing with rentals. If someone's buying it for an Airbnb when they know Airbnbs aren't allowed in the building, you just want to spell it out that it's there. The seller will notify the buyer before the completion date of any notice for resident to amend the bylaws. I won't go over that one really at all. It's just, it's a standard one. It's straight from web forms. It should be in every strata contract. The interesting thing though is, of course, if the bylaw changes that pets aren't allowed after subject removal, your buyer doesn't have any way out of the contract. You're simply informing them of that. But it is something that should be in every strata contract for sure.
Steve, something I do with my contracts, when rather than have the maintenance fee as this and details like that, I'll print off or screen print the sheet and then just put a ring around all the information. Like I'll ring around the management company and the telephone number, the bylaw restrictions, the size, and things like that, so that they've actually, then when they DocuSign it, they're putting initials right by it. And I'll just talk them through it. Like, you know, if you have any other information, contact the management company, and you've initialed that I've given you the management company's telephone number.
Most management companies won't talk to buyers until they become owners, though.
Fair enough.
Yeah. And that's good. The only thing is that's not part of the contract. So
Yep.
I think when you're wanting some things to be warranted or understood, putting them in not every little thing, but the important ones, putting them in the contract makes it part of the contract. That's a little.
But it almost isn't part of the contract. It's got nothing to do. It's just the buyer acknowledging something.
Oh yeah, and that's fine, because again, if the buyer comes back, that's a cover your ass thing, which is always a good idea. I recommend because if they come back to sue you, you've got something in your file that says, look, you acknowledge this, you initialed it, which makes it hard for them to prove anything. And that's a good point, that not everything has to be in the contract, but you may want to make good notes or have other things initialed to put in your file. Because everyone's happy until they're not happy, and then the first person they sue is you. So Lori just said, can't you tell what's included by looking at the financials? Agree with Lori, gas would be a line item. Yeah, it probably would be. I'm sure it would be. But do you actually go through that? It looks like you guys do, and you look for that. But would you necessarily catch that it's not included? Would that even show you? It's just a line item of an expense, but it wouldn't say whether it's included in the maintenance fee. Yeah. Dave C. and Lori, not always. I've seen it where the strata will have gas bill for common expenses, but the strata lots have their own gas bills. Yeah, so I think having it in the contract just makes more sense. But essentially, it's not a material part that the buyer could get out, is kind of the point that I was trying to make on that one. All right. So here's where we've got an or. Now, please, if you're using this template in the future, don't leave both of these in. They're meant to be a selection. Choose one. Don't leave both. So a lot of you are using this, which is great. The reason we recommend it is because of the 20% added tax. And it essentially forces you to have that conversation when you're writing the contract and gets the buyer to acknowledge it. It's a little more real when they're actually acknowledging it and they see the numbers there. And then it may trigger them to say, oh, well, you know, my permanent residence is going to be coming any day now, versus that they are a permanent residence, right? So choose one of these, because if they're not a Canadian citizen and they're going to have this 20% extra tax, you could find that collapsing the deal if the buyer can't come up with the extra 20 grand, 80 grand, 100 grand, whatever it is, because if it's unexpected. So this, we really, it's essential. We want you to have it in all of your contracts. It covers us and it covers you. You should have it in there. So that's all I was mentioning about that one. So GST, we touched on a little bit last week, and I want to go into a bit more detail with it this week. In my opinion, and I think as a brokerage, we're basically saying you should have one of these in your contracts because we've seen it at my old office. I'm not sure if it's happened here yet, but GST is another one of those things where no one, for example, no one thought that GST was due and payable on properties that just completed, buyer never moved in, and then turns around and sells it after never living in it. I remember selling those myself, and GST was never applicable. You would always put GST already paid, and it wasn't an issue. The law actually hasn't changed. They just started enforcing it. And so we all got kind of a little bit caught off guard. And I know one of the agents at our old office got caught on this because the GST clause wasn't specific enough. We probably could have fought it, but in the end, it was just decided that it's not worth fighting. And so that buyer had to pay the GST. But now we also have the issue where with those same properties, you could end up paying, or the buyer will end up paying GST on the lift and the full amount. So it's not just the lift unless you negotiate it, right? Because let's say it's a $500,000 condo, they turn around, that's what they pay, they turn around and sell for $800,000. What's going to happen on closing if you don't deal with it is the buyer will have to pay GST on $800,000. The seller's already paid the GST on $500,000, but he's going to get that back. So you need to make sure that you cover it. And if you put one of these two clauses in, depending on whether they're a resident or a non-resident, it covers you. So if it's a seller, the purchase price is $800,000. Seller is solely responsible to pay and remit any GST payable. The buyers are only responsible for paying the purchase price and are not responsible for paying GST on top of the purchase price. There is a shorter version of that, which is in our Stillhaven clauses. I've seen a lot of you use it, which is fine to use. It's good. This one to me is clearer, so why not use it? And then the important thing is, though, if the seller is a non-resident, the buyer is the one who has to remit it, even if the seller is paying it. So that's why the residency is important. So if you have a non-resident seller, you should be using the second clause. If GST is payable, GST is included in the purchase price. If the seller is a non-resident, purchase price will be deemed to include GST, and GST will be payable. GST will be backed out of the purchase price. GST equals this, that's just for calculation. And the buyer will remit GST to CRA because they're responsible for the CRA if it's a non-resident. So I just want to make sure everyone understands that. So it adds a little bit more burden on you. You can't just use the one clause in all your contracts. Make sure you have this for your non-residents.
Steve, a quick note just in reference to assignments. I don't know how many others have done a lot of assignments, but on the listing side, people may or may not be aware that you have to actually pay income tax on not only your lift, but on the replacement of deposit, which seems egregious and outrageous, but that is how the CRA treats it.
I didn't know that, really.
If you're working for a seller, that you inform them. And I've actually got a sheet that's like a form that includes that as part of whenever I'm taking an assignment listing that outlines like here are your tax issues at the bottom, so they're initialing off on them. And
but they paid that with after-tax income, and then they have to pay tax on it again when they get it back.
Believe it or not, well, yeah, yeah, believe it or not, it's outrageous, but it is.
Wow, that really is double dipping.
Yep.
And there's no way to get they don't have to pay it and get a credit. They just have to pay it. It's done. Wow. Okay. And then so with GST and again with that issue, always have it clear and in writing that you've given your buyer advice, or your seller if it applies, to get independent accounting advice. There's also, in addition to the resale condos that have never been lived in, there's live work studios, and there could even be regular condos that were bought by a corporation to rent out, and the GST was just deferred and never paid. So there are situations that are more rare where GST may not have ever been paid, and it could have turned hands a couple of times. And if your buyer is the one that buys it and gets caught in the end, they'll be the one responsible for paying GST. And again, it's rare, but it can happen. Live work, it's less rare. Often if, let's say, a photographer bought a live work studio, they have a GST number, they defer the GST. When they sell it, if they don't pay the GST, the buyer's gonna have to pay it. There's no registry to look and see if it's been paid or not. Only accountants can really tell you that. So it's important in those situations to make sure your buyer discusses it and get it in writing in an email or text, so you have evidence that you advise them to get independent legal advice, and maybe even put it in the contract. But by putting these clauses in, at least you're covering it. Now, with the example of the live work studio, if it doesn't get caught on closing and it gets caught a year later, at least having this clause in gives your buyer the ability to go back and sue the seller or demand, hopefully not sue them, just demand it and they'll pay it, the GST, so that the buyer pays it, but then they'll get it back from the seller after demanding it or suing them. It just gives them the ability to do it, because if it's not in there, you don't have that. Okay, so here's dealing with square footage, because again, these are just in the 10 years or so that I've been doing this. One of the more common things that comes up, because everyone is so focused on the price per square foot with condos, especially, if it turns out that, you know, they bought it and it was 900 square feet, or told it was 900 square feet, and then they go to list it 3 years, 4 years, 5 years later, and it's really 825 square feet, then they're pissed off about this $75 times $1,000 a square foot or whatever it is. So you always want to make sure that you've got something like this. I like this one because it's a little bit more detailed. So notwithstanding any and all representations made, the buyer is satisfied with the size and square footage of the property improvements as viewed. The buyer acknowledges that the information and the measurements they have received are not guaranteed to be accurate and therefore should not be relied upon without verification. And again, usually, unless it's a crazy amount, if this ever goes to court, the court's going to look and say, okay, Mr. Buyer, you're not happy that it's 75 square feet smaller. But when you looked at it and you saw that the living room and the dining room and everything was a nice big open plan, that's what you bought. You appreciated and found value in that. So you can't turn around now and say that because it's 75 feet smaller that you never noticed before, so it didn't affect your use and enjoyment. Now that's super important. And I know people might argue that we do put a lot of emphasis on price per square foot, but that's not what the courts are going to look at, again, unless it's something that's a very, very large amount. The seller's warrant and guarantee that there are no outstanding work, fire safety permits, or health orders with any municipal authority. I've never had that in mind before, and I recommend it now, and I've seen it in a lot of contracts already. And only again, because if there's work done without permits and the city knows about it, then, and let's say they found out about it and they're put a note on title, or they told you have to take it out, or there's a work order that has to be brought up to code that you don't know about, again, it just puts the seller on notice. A good example of that is the lofts, I think they're on Richard Street, where everybody put in a second level in those lofts because they had the space. And the city found out about it. And I don't know if anything's happened since, but there was a note on everyone's title. So you either saw it on the title, or if it wasn't on the title, then at least this would force the seller to tell you about it.
Steve, that clause, the way it's written, it's pretty ambiguous. Does it pertain to the unit itself, to the whole building, to, like, it doesn't state?
Well, they can only warrant they can only warrant their own unit.
Okay.
I suppose you could say I could reword it for strata. I just don't want to have too many that are strata, non-strata, because this covers both. But you could put the seller's warrant and guarantee that there are no outstanding or health orders pertaining to their strata unit with any municipal authority, if you wanted to be more specific. But then, like I said, if we start doing that with every clause that's meant to be sort of used in both situations, it's up to you. I'd say you could do it, yeah, if it was important. The buyer had been advised to contact the local municipality for information on any zoning changes, development applications, or other improvements that may impact views, traffic patterns, or their subjective use and enjoyment of the property. I really like that clause, and I've seen it being used more and more recently. And again, I never used it in my contracts. And I sold a lot of high-rise view apartments. And this actually makes sense because you can never really guarantee what someone's view is going to be 2 years from now, 5 years from now. Traffic patterns are always changing, and the use and enjoyment is so subjective. So this is a good clause for sure. I think it should be in every strata contract. And then, of course, we're not experts, so don't give any advice outside. And this is just acknowledging it. So the buyer understands that neither the selling brokerage nor its representatives warrant or guarantee any information concerning the property that's received from the listing brokerage. Obviously, it doesn't absolve you from doing your due diligence that's required as a buyer's agent, but that you're just putting it in here that the buyer is urged to carefully read these documents and confer with professional advisors. Additional information can be requested from the seller or an independent source, including Strata Corporation or Land Title Registry. And then the buyer and seller acknowledge that the broker is providing agency service to the buyer, and the seller and their representative designated agents do not provide legal or other expert advice beyond the scope of their agency duties. Buyer and seller are advised to seek independent legal and or expert advice pertaining to the purchase. I've seen many different versions of that, so just make sure you have something like that. This one, from all the ones I saw, this one seemed a little more comprehensive, so that's why I like that one. But
I
again,
have a question.
Yeah.
Sorry. This clause has gotten us into some difficult situations where a buyer's agent has written that And basically they're telling us as a listing agent that we have told, telling us that we've done something with our sellers that we may or may not have done. And then
Which one? Sorry, the second one?
The second one about legal advice. And so then we had a seller on like, a Saturday afternoon refusing to sign an offer because they freaked out and thought that they should have a lawyer review the offer. Like, I just personally don't like somebody putting words in my mouth as a seller's agent. Like,
right, I see what you mean. Yeah, because it says buyer and seller acknowledge.
Yeah, they deal with their client. They say that they've advised their buyer to have legal advice, but how do they know what I've advised my client?
Yeah, and that's fair enough. There's a lot of clauses that have buyer and seller, and in fact, the first one had buyer and seller, and I thought the same thing. I thought, well, we don't want to be including them if we're the buyer's agent. You could take the seller out if you want, for sure, and it may not be a bad idea because I agree with you to some extent. The only thing that the way I looked at it was that most listing agents would probably prefer that the buyer is also covering them, but I can see from your point where you don't want that. So
I have a question on that. Is I had people that were fairly new to Canada, they'd never bought here before, and their question around that is, well, before I write an offer, do I need to bring this to a lawyer? And I mean, it's a really difficult question to answer because we're supposed to tell them to get legal advice, but yet nobody does it. Nobody takes an offer before they write it and takes it to a lawyer to review, or very few.
yeah.
How does everyone else handle that?
Well, I'll say what I would recommend, and then other people can chime in. That's when you make it a subject. So if you know your buyers are concerned, then I would make it a subject. So
okay.
And Gavin's saying he's had massive pushback on that too. Yeah. I mean, I have no problem changing to just be the buyer acknowledges, because I think really the buyer on our end, we're just looking after protecting ourselves. So I can reword that easily. It's not necessarily a bad idea. I just thought the sellers agents the listing agents would like to be included on that part of it. But if you don't feel that way, you guys are the ones out there. I can change it. But anyone have any different thing for Ina? I was just saying that if somebody is concerned that, well, you're telling me to get legal advice, but I don't want to sign the contract, then the solution to that to me would be make it a subject. And then if they don't like what the lawyer says, or they don't take it to a lawyer, they can just waive it. So.
Well, it was more, they're saying, what should we do, Ina? Do you want us to go take it to a lawyer? And, my answer really was, nobody does, but I'm supposed to tell you that you can. like that's in all honesty.
Yeah, and this is a cover your ass clause. So I think, and Ben is just saying, to talk it through with your clients. So I think you just have to talk it through with them and see whatever makes them comfortable. You're right, most people don't get independent legal advice, but it is a legally binding contract, so maybe they should. So you just have to be honest with them and say most people don't. We're just putting that in there as an option for you. If you'd like to, you have that option. Yeah.
I mean, you do have in there that, beyond the scope of agency duties. I mean, one of our duties is to draft a contract, right? We're just saying that we're not a lawyer and we're not advising on other topics, but doing a contract, that is our duty, right?
Oh yeah, for sure. And your job is to create a legally binding contract. You're expected to know how to do that. So this is not saying that I've done something wrong as the agent, or I may not know what I'm doing. It's just saying this is a complex transaction, and if you want to have somebody review it, you have that option. And if they're concerned about signing it, I would say, like Ben says, just talk it through with them so they understand. And if they're still concerned, change it to a subject, and then they have a way out if they want. And sorry, going back to unrepresented, that just reminded me, if you do have an unrepresented offer, it must be subject to independent legal advice. If you're the listing agent and you have an unrepresented buyer, you can't say we recommend you have it, or we've advised you to get it. It has to be subject to. They can cross it out, they can waive it, but it has to be subject to, because no one's representing them, and so they need to know that they can take it to a lawyer. So just to clarify that, since we were talking about it. Okay, so this is just talking about material latent defect and tendencies. Again, this is not every strata. I'm just throwing this in as an example because I wanted to talk about material latent defects, because I'm still having most people do it incorrectly, and I just wanted to use this opportunity to touch on it. And then of course, tendencies can be quite complicated, and obviously I'm talking about tendencies in a normal situation, not in a COVID situation. So keep that in mind as well. So the seller will give legal notice to the upper floor tenant to vacate the premises, but only if the seller receives the appropriate written request from the buyer to give such notice in accordance with the requirements of Section 49 of the Residential Tenancy Act. So please make sure you add this to your contract if you're expecting vacant possession. I know some of you make other arrangements, mutual agreements to end tenancies, and that kind of stuff, which is all fine as long as you make sure that you get a copy of it and you know that the tenant is actually leaving early. But this is assuming you want full 2 month notice for the tenant to vacate. You have to put it in here because the seller is not giving notice for owner use because he's not using it. The seller is giving notice for owner use on behalf of a buyer. And the requirement in the Residential Tenancy Act is that the buyer, after they remove subjects, has to give notice to the seller to give notice for their owner use to the tenant. It's just a requirement. So make sure it's in there. And in this case, I'm just using an example where there's a lower suite and an upper suite. The seller warrants that John Smith is a tenant occupying the basement suite. Monthly rent is $1,800, including heat and hot water, payable on the first of every month. So this is straight from web forms. Make sure you fill it in. It should be there. It's just the basic information from the tenancy as well. And then this one,
it's a question about possession. So I think in this case, it's important to remember to make sure under the possession that you're putting the subject to existing tenancies for both here, because you can't guarantee vacant possession unless you get that notice. So should you still put, just confirming, you should still put in both the tenancies in the possession.
Well, no, so I don't have it here, I don't believe, or maybe I do. Hold on, is it on the next slide? No, it's not. So where it says vacant possession, you would make a note like vacant possession upper floor, or you just say vacant possession, and then where it says existing tenancies, you'd say lower unit to remain tenanted or lower tenancy to remain, something like that. So you're only concerned about the lower tenancy.
But if you don't receive, this is only if you get the appropriate written request. So if you don't end up getting it, like they change their mind, then you've put in the contract that you've guaranteed vacant possession of the upper floor, but you've never got the appropriate notice.
Sorry, I don't understand what your concern is. If you're the buyer's, are you talking about as the buyer's agent?
No, more as a selling agent.
Well, it's your seller's job to give the proper notice. That's your job to make sure they do, right? As the listing agent.
But you can only do that if you have direction from the buyer.
That's
what I think Rob is saying.
Yes, and what I would say, if you're not getting it, I mean, you need to be proactive. If you're not getting it from the buyer's agent, let's say they're new or they don't know that they're supposed to do this, you've got a couple of options. You can hound them for it, or you can just give the notice anyway, because you know you're not technically supposed to do that, but you're more concerned about not giving vacant possession. So
yeah, like what we usually do, just because you have to put possession in the contract when the contract is entered into, but you don't know whether you're getting the Section 49 notice because subjects haven't been removed yet. So I always put in subject to both tenancies, and then you can only give notice, so that if you don't receive this notice, then there's the tenancy still exists.
Well, no. So so I just want to make sure I understand. If you have a tenancy and then the clause is in there that they will give you the notice. Once they remove subjects, that's when they give you the notice. And then yours as the listing agent and the seller, you're supposed to give notice to the tenant on behalf of the buyer. So why wouldn't that happen?
Can I step in? Because I think I can clarify for you what each of you is saying to the other. It sounds like, Rob, you're saying that in the page 1 or 2, I guess it's page 2, that you still have to put subject to those tenancies. And in addition, you have this clause. I think that's true in both cases. Both cases are true. It's subject to the tenancy. And then this clause deals with, but only if the seller receives the appropriate written request. So either it's vacant possession or not, depending on if they get it. I think you're both agreeing.
Right. What I'm trying to avoid is I had a situation where we had the buyer agent put this clause in, and then we said vacant possession, and then the buyer never ended up giving us this notice because they changed their mind. And then we've guaranteed vacant possession already, right? But we can't give the notice. So I think it's just important to put in.
I see. Yeah.
That's what I'm trying. Yeah.
I mean, those seem rare, but sure, if you've encountered it and you're nervous about it, then sure, that would be not a bad idea. Yeah.
Hey Rob, couldn't you just in that situation, in the actual, like where the possession date is and it says vacant, couldn't you just cross that out and say see addendum, and then just refer to this clause, and then you're only giving vacant possession if you're given notice?
Totally, yeah. Like I think the important thing is you can only guarantee vacant possession if and when you receive the written request. So it's got to refer to that.
Yeah. I've never heard of them changing their mind, but obviously you had that happen. So yeah, I would say protect yourself in those cases.
Because there'll be some buyers, I'm not sure if I'm going to move in yet, and then I'll get the notice.
Yeah, okay.
So I think, Rob, if you're thinking about the clause like number 5 for possession, right?
Yeah.
I think the important thing is to make sure that you, as Steve's contract here says, lower suite tenant to remain. Then the clause is here, and we're going to try our very best to satisfy section 49. But first of all, do we even have enough time to even give proper notice?
Exactly.
If subject removal occurred on the 31st of August, how are we going to give notice on that day?
You can't, unless you hand deliver it. So.
Exactly. So at the end of the day, the tenancy law runs with the land. So we can only do as much as we can.
Right.
Yeah.
Regardless of what that line says.
Yeah, and to add to that, so Rob, I mean, the situation you had, obviously, if you dealt with it directly because you've had that situation, that's great. But I think in general terms, if the buyer changed their mind, they put the clause in because that's what they wanted to do, and you were supposed to give notice, and now they don't want vacant possession. That you can only give vacant possession if they give you that notice. So by them not giving you the notice and changing their mind, they're not expecting vacant possession.
Correct. Yeah.
Or it's just not in time, right? There's not enough time to give them the full 2 months notice.
Well, that's your job before, that's part of negotiation. We're assuming that this is all being done properly, right? So, yeah.
Hey, Steve, one thing to add to this that we may want to consider is just dealing with the 1 month free rent when giving the 60 days notice. I know that this comes at a left field sometimes for sellers, and maybe having it in the contract and how that's going to be dealt with would be a smart thing to do as well.
Well, there would be a similar clause to the middle one where it says that now again, this middle clause may not be necessary. Often the lawyers will just do it. In fact, most of the time they will when they see there's a tenancy, but I like to add it in so that there's no doubt. And I've had some situations where some notaries missed it and then they didn't get the damage deposit. So the seller shall credit the buyer on the buyer statement adjustments, $900 plus interest as stipulated by the residential tenancy branch, which is $0 right now, by the way, and it has been for years, to reflect the payment from the seller to the buyer of damage deposit currently held by the seller. You could modify that clause in the situation that Rob's talking about so that you could get back that 3 months rent at the end. In most situations that I've seen, the seller will be the one paying it because it's their tenant. Getting rid of them shouldn't cost the buyer any money, but that's a negotiation. So you may have situations where hopefully the seller's aware of it and you may want to bring it up during the negotiations, because if they feel adamant that they don't want to pay that because it's the buyer that's making the tenant leave, then you negotiate it and you just make whatever arrangements, just make sure it's clear. The buyer acknowledges so this is assuming this is an unauthorized accommodation. So dealing with material latent defects, and we're all getting much better at it, but we're still not doing it really properly. So the material latent defect requirement is that separate disclosure of a material latent defect be given. So separate from the contract. The PDS again can be used if it acknowledges and discloses the material latent defect and exactly what it is, not just check off that there's a material latent defect. It has to be telling you it's unauthorized accommodation, work done without permit, whatever. So in this case, you could use the PDS as long as it's not subject to the PDS, but in this example, it is subject, so you wouldn't be able to use it. So you'd have a separate material latent defect disclosure. And a lot of you guys are doing that, which is great, but you're not going the one step further and putting this clause in. So the buyer acknowledges having received separate written disclosure of a material latent defect related to whatever, in this case, unauthorized accommodation. So that is required, and the buyer's agent will often forget to put it in. So as a listing agent, if you're the one who's giving the notice, then also make sure that this clause is added to the contract. And the buyer is aware that the property contains unauthorized accommodation. That is not the required disclosure. It has to be separate from the contract. So you can't just rely on that clause, which a lot of people do, as your disclosure of material latent defect. The reason I included this one as well is because as the buyer's agent, I want to make sure that the buyer is aware of the consequences of that ownership of an unauthorized accommodation. that they could lose that income. So that's a cover your ass clause. So that's why both of those are there.
Steve, I just, I've got a contract where that's in play presently. Initially, we had it in the property disclosure statement. And initially, the property disclosure statement was not a part of the contract. So they received it separately. And later, as part of the negotiation, it was subsequently added to PDS. Would that, I mean, does that still satisfy that it was separate? It was separate before they actually wrote the contract.
As long as it was separate and delivered prior to the contract being accepted, which would mean they would have to acknowledge it somehow.
They initialed it when they sent it to us as part of their offer, but it wasn't included in the contract as part of the offer.
No, so that would still work as disclosure, but you should still have this clause in saying that they acknowledge having received that separate notice. That should still be in your contract.
So that's not presently in there. And I guess that's my point. And is that something at this stage that I should be worried about?
No, just for next time. I mean, it's to be honest, it's as Rob Zwick mentions to me usually once a month or so. No one else is doing this, so you know we're so much on top of it by doing this. It's not going to be perfect, but I'm just saying this is what's required. This is what the Real Estate Services Act says we need to do, so we should be doing it. We're trying to raise the bar, so let's do it properly. But it will be for next time for yours. I mean, you can't go. There's no point in going back and trying to fix it because it's already not done properly. So. Okay, so that was all for that one. Okay, so then note request for the seller to end tenancy. You probably have all seen these. There's actually two different versions. We have a Stillhaven one, and then there's also one from BCRA. You can use either one. So that's the request to seller to end tenancy for owner use. And I just want to quickly talk about the substantial renovation notice because I haven't seen any of you guys do it, which is great, but I do still sometimes see it on the other side where they're trying to give a notice to end tenancy for substantial renovation. You just really, it's almost impossible to do that. For one thing, it's a 4-month notice. These are the requirements of the Residential Tenancy Act, that extensive renovations are so extensive that the rental unit must be vacant in order for them to be carried out. As the only way that you can achieve vacant tenancy. Cosmetic renovations, which is what most people are contemplating, like minor repairs, painting, changing light fixtures, flooring, cabinets, that kind of stuff, they're not considered major renovations. You wouldn't be able to use the substantial renovation clause. But you know, rewiring the unit, replumbing the unit, reconfiguring and moving walls, that would all be considered substantial renovation. So just make sure that you're aware of that, because I do sometimes hear, because the buyers may not be aware of that, and they say, well, we can get rid of the tenant based on substantial renovation. Well, you probably can't, and so just be careful about that. I just wanted to mention it quickly in case anyone was confused about that. Oh, and the other thing is you have to have all permits and approvals in place before even issuing it. So as a listing agent, you would never be able to issue a substantial notice renovation on behalf of a buyer because they have to get the permits first. And everything that would be considered a substantial renovation would require permits. So, and just for fun, I threw in recommending the terms to get paid your higher fee. So let's say you're dealing with, you know, 1% realty, and your buyer wants to, your buyer's agreed to help you get more money from the buyer. Essentially, CREA, the Canadian Real Estate Association, doesn't allow realtors, it's a violation of our code of ethics for CREA to ask for more money in the offer, in the contract of purchase and sale. You're not allowed to do it. BCRA for our province has negotiated with CRA to allow it under certain circumstances. If you just put a clause in there saying that, you know, the seller agrees to pay Steve Jameson of Stillhaven Real Estate Services this much money, you're putting yourself into the contract, you're making a contract within a contract which is voidable. So if you use the wrong clause on closing, a smart seller's lawyer could end up saying, do you want to pay the buyer's agent? Because the way it's written, you don't have to. So don't go to all that work and then not be able to get paid your fee. There's a very specific way it has to be done in order for you to get paid. The first thing is you have to get your buyer's permission, which I'll show you how you do that in a second. And that's separate from the contract and ahead of time. So you've already had the conversation with your buyer. You know, this is one of those discount brokerages we discussed. I'm going to put a clause in the contract asking for my normal fee. Are you okay with that? And they say yes. They sign a form, which I'll show you. And then you have to, so that's the first step. Second step is letting the listing agent know that you're doing that. That can be a text message or a phone call, but you do need to let them know that you're doing it. You have to inform them. And then you put it in. They could cross it out. It could become a negotiation, but you do have to let them know ahead of time that it's in the contract. And then you have to put a clause like this where you're not putting a contract within a contract. So the parties of this contract, so it's already the two people that are in the contract, are agreeing in direct that the purchase price includes the payment of a commission to the buyer's agent of whatever it is. And this is the second part, acknowledging the buyer acknowledges that they have authorized a cooperating brokerage, Still Real Estate Services, to modify the listing brokerage's offer in a separate written document. So that's the thing you have to get done ahead of time. This is just the part from the CREA exemption from the BCRA exemption from the CREA Code of Ethics rule. So the buyer has authorized the realtor to do so in a separate document, and there has been prior consultation regarding compensation between the realtor and the listing brokerage. That's just stipulating you have to let them know about it. And then this is the form that we have. There used to be a web forms version of this, and I can't find it anymore, so we just created our own. But essentially, they're just acknowledging and giving you permission to put that clause in. So again, it's a process. I just want to make sure everyone's aware. If you are dealing with discount brokerages, please follow this format to guarantee that you get paid your fee. And then again, just for fun, so we talk about it as assignments, adding names to the contract or title. There's lots of different versions of these clauses. You obviously wouldn't use all three. I just put sort of three of the more common ones. So the buyer and seller agree that the buyer may, without consent of the seller, partially assign its rights under this contract and add additional buyers to title on closing. The additional buyer will be added to title of the property on closing. Or notwithstanding section 20 of the contract, the parties agree that the buyer may, without the consent of the seller, add so-and-so as an additional buyer to the contract prior to closing. You notice this one says to contract and not to title on closing. The seller's consent does not release, typo there, release the buyer from liability under this contract. And then in cases where they're not sure if they're going to, but they want to reserve the right to assign it, the buyer reserves the right to assign this contract in whole or in part. So the last two are directly from web forms. The first one is one that Richard Bell gave us years ago when this first came up, that contracts couldn't be assigned anymore. And there's a whole bunch of different versions of these in our Stillhaven clauses as well, which you all have access to. So please take a minute and go look at those. The other way, of course, to allow assignments, which a lot of people don't even think about, you don't need any of these clauses if you just cross out 20A. So that's the other option, right? All contracts are assignable at law, and they used to always be allowed with these contract to purchase and sale. The only reason they're not now is because they added 20A. So by getting rid of 20A, the contract's fully assignable now. So that's your other option if you want to do it as well.
Hey, Steve, I have a quick question on that. If you go back, the middle statement says that notwithstanding section 20A, if that's the case, like we've always crossed out 20A and used this clause, but I would think that like notwithstanding actually allows you to not have to cross out 20A.
You don't have to. So any clause you add that modifies 20A is the clause is what would take precedent over 20A anyway.
Of course.
So I see most people not crossing 20A out, but the recommendation, the proper way to do it that they recommend is if you're modifying 20A, whether it's just A or just B or both, because you could cross out that it can't be assigned and then leave the part where the, leave the part where if there's a profit, it goes to the seller. If you leave that intact, you don't cross it out, that'll often make the seller feel a lot more comfortable about an assignment because they realize you're not doing it to trick them or to get profit. You're simply doing it because you want to close it in your wife's name or a corporation name. So you can choose.
So the second way of doing it is acceptable in your opinion, where you just cross out the part of 20A and actually not.
I mean, if you cross out, I mean, the whole reason you're doing the other clauses is usually because you're trying to make the seller comfortable or let them understand you're not doing it for any nefarious reason. But the fact is, if you get rid of 20A, all contracts are assignable.
Yeah. Okay.
So, yeah. And then talking about this, so prior to acceptance, because this is still getting done incorrectly fairly often, if you have a partial assignment or a full, well, you wouldn't have a full assignment. So if you have a partial assignment where you're adding someone to the contract, you're removing someone from the contract, you want the option to close it in the name of a corporation, the mortgage tells you to add a spouse to title on closing. Those are all partial assignments, and a partial assignment still needs the notice to seller regarding assignment terms, We've had some pushback from some other brokerages saying that if it's your wife, you don't need it. That's not correct at all. And I double checked with the lawyers on this one. If you cross out 20A, any part of it, if you add a clause that modifies 20A, you need to have the notice to seller regarding assignment terms if it's in your contract prior to acceptance. But if it's a week after acceptance and the bank tells you you need to add Mary Smith to title on closing, then go ahead and do that. But that is then it doesn't need the notice to seller regarding assignment terms. So if you do it in your contract, you have to have this. And as the buyer's agent, it's your job to send it with the offer. Now, a lot of you obviously are listing agents. If you're on the listing side, and I think this is where it gets missed a lot, is if you're on the listing side and you see that there's an assignment clause or you see that 20A has been crossed off and the buyer's agent didn't do what they're supposed to do, which is fill this out and send it to you, then you need to do it. You can push back and ask them to do it, that's fine too. But ultimately, if they don't do it, you need to do it. It needs to be done before. Or if they might need a co-signer. Yeah, exactly. There's lots of reasons you might have these different assignments, but just keep that in mind. So prior to acceptance, you need that. After acceptance, it has to be on an addendum. So let's say a week later, they want to add Mary Smith to title. Now be careful because you are opening the contract. If you're doing it prior to using one of these clauses, then you've already said that the seller has given you permission to do this without consulting him any further. It's already in the contract, it's allowed, you're not opening the contract. Doing it after acceptance, you are opening the contract. So we recommend that you use this repudiation clause, which essentially says you're not doing what you're doing. And it doesn't matter if you say you're not doing what you're doing, you're still doing it, right? And I've checked with lawyers on this. I'm not a lawyer, you're not a lawyer, but ultimately changing the parties to the contract is opening the contract. And if who knows what would happen if they took you or if your clients ended up in court on this, but technically you're opening the contract, there might be a backup offer. Just be aware that it's risky. Using the repudiation clause at least puts everybody on the same page and they're all agreeing to it and they're supposed to act in good faith. So it just makes it a lot safer. So you'll do an addendum, you'll put this first, and then you'll put one of the other clauses like this. And again, there's a bunch of them in our Stillhaven clause section, depending on the situation. The most common is going to be this one. Pursuant to section 28 of the contract, the seller consents to the buyer partially assigning its rights under the contract to Mary Smith. The additional buyer will be added to title on closing on the property on closing. In the event that there's a conflict between the terms of the addendum and the contract, the parties agree that the terms of the addendum will prevail. So go ahead and do that and get it signed, and then you're good to go. Any questions on that? Because I just wanted to make sure that everyone's clear on the before acceptance and after acceptance as far as when you need the notice to seller regarding assignment terms. Good. Can you go back one slide? That one? Josh has asked me to go back to one slide. Can you go back? Okay, perfect. Yeah. This is also recorded, so you can go back and see any of these. And again, this repudiation clause is in our Stillhaven clauses. So if you ever need it, just go in there. And we recommend you using that, not just in this case, but any addendum you do after acceptance should have this repudiation clause before and then whatever you're proposing, changing the closing date, changing the amount of the deposit, anything like that, you should always have the repudiation clause ahead. All right, notice the seller regarding assignment terms, talked about that. Okay, subject-free offers. I just wanted to touch on this quickly. I'm seeing kind of all over the place on what people do for subject-free offers, and I just thought it'd be a good chance to talk about it. There's different ways you could do it. You could leave subjects out completely, which of course is not recommended because then you don't have any evidence that you've had any kind of communication with your buyer about the dangers of not having an inspection or the dangers of going in without a financing subject. You can cross out the subjects. Again, it's not recommended, and I know a lot of people are doing it. And when you think about it, it seems fine because you're just crossing them out. At least they're there and they're acknowledging that they are crossing something out, they've read it. But the problem is certain things you may not want to cross out. So the PDS, for example, if you just cross it out, then it's no longer incorporated into the contract if you cross the whole subject out. And if it's no longer incorporated into the contract, then if the seller's lied or misrepresented something on it, you can't use it against the seller. The other one is the financial charges, the section 9 trap. So if you cross out that whole title section to make it not a subject, then potentially if there are any non-financial charges like an easement, the seller can't remove that. The buyer could have a way out. So it's not a good idea to just cross them out. And then you also have nothing to show that they've read the minutes and the rest of the stuff that they're supposed to do. You can reword the subjects to show they've been waived or satisfied, and that's much better, of course. So you just take, subject to the strata documents, you say the buyer has reviewed and approved the following documents. You just reword it. So at least that's sort of a positive way of doing it as opposed to crossing it out, and it leaves the section 9 part in there. It leaves the PDS as being incorporated. Some of the ones in web forms are already worded that way. Other ones you may just have to, reword it yourself, but that's definitely better. And then I think a lot of people aren't aware, we have a sort of a buyer waiver in our Stillhaven forms. So you could use this if you wanted to. And it just basically says not applicable, waived, declared, fulfilled. My screen's not as big, so I can't really read it. But it deals with title, financing, inspection, all the different things. And it gets the buyer to acknowledge that they've waived their opportunity to do all these things. It's not part of the contract. It's a cover your ass thing when someone's going in subject free. So it's in the Stillhaven forms if you want to use that. It's just a good idea. If you do use that, please upload it into Room so that we have a copy of it as well, because we'll keep all of these documents for 7 years or longer. That's it. Any questions?
I have a question.
Yep.
Just looking at everything that we have in this contract, which is lots of information. And this is a question, I guess, for realtors that either you're receiving a contract that looks like this or you're writing a contract. A lot of condos have sold in multiple offers in the last 6 months. So does anyone out there have some advice on how to best represent your client but win beyond just paying more or having a bigger deposit?
I will jump in. It's Maria. I've had this couple times in multiple offers. So what I did, because I have 3 or 4 pages of the addendums or terms and conditions, I phoned the realtor and I pretty much, first I said, I'm sorry for sending you a long contract to go over, but I sent it to him, send him the pages ahead of time. And I said, listen, here it is. If you need to talk to your seller, but here are the terms and conditions I will have in the contract, just so you don't waste time reading it after. So he knows that it's going to be long. I kind of apologized, but I said, you understand I need to protect my buyer. So here it is. And I did it twice and they kind of appreciated it a bit, but they were older realtors and they totally understood that, it's my job. And we won. So anyway, that was my experience.
Thanks. That's great. I'll just chime in real quickly. So if you're trying to make your offer stronger, obviously getting rid of the seller warrants and the seller will do this and the seller will do that, that'll help. So those are kind of either cover your ass or they're fluff ones. Some of the clauses that are in there, you may also be able to just not have in the contract if they're more of the, again, the seller warrants covering your ass. You could get something in an email so that you have proof that you discussed it with your buyer without having it in the contract. So that's one way of doing it as well. There's certain things that are essential that you really shouldn't just take out. And I've seen some people just put, the buyer acknowledges this is a subject-free offer, and then it's, hardly anything there. If you're going to do that, it's a big risk in case something happens because you're not showing you've done any of your due diligence that you're supposed to do. Then again, I would recommend having some emails saying, look, as per our phone conversation or as we discussed, I'm making this offer very bare bones, but we have talked about this, and this. So just again, keep a copy of that email in your file because again, everything's fine until it's not fine. So.
I'll add to that. The one thing I would say is that if a long contract necessarily isn't a contract that isn't as advantageous to go with, because I'll give you an example. I once got a subject-free offer from Evanston, and it literally had 3 sentences on the addendum. And I explained to my seller that because this contract is very vague and it doesn't deal with a multitude of different things that can go wrong, it's actually less safe for us to accept something like this than a contract that is detailed that covers all necessary situations. So I would say that, explaining to the agent that, listen, this contract is long just because it's dealing with every aspect of what could go wrong, and we have an answer to that situation. And most of the time, agents will actually appreciate that if it's spelled out to them a bit.
Yeah, that's a good point.
You're a very good realtor, Rob, because I actually was told straight out on an offer I wrote last year on a place in Whistler that we lost. because my contract was too long. And I had my previous manager ask me why I put all these conditions in my offer. And they were all basic and pretty much exactly what we have just covered. So I didn't even get support from the management. So not all realtors think alike. I totally agree with you, but it's tough out there, right? Like a realtor can come from many different backgrounds before becoming a realtor, and unfortunately, they don't all see that.
Yeah.
And I think by holding someone's hand through the process, it's like doing a deal with any new agent. You have to kind of coach them through the process and tell them what they need to tell their client in order to have an effective way of walking through this type of more complicated contract than what they're used to seeing. So I think it's just all about communication and trying to get ahead of what may sorry, I'm getting lots of feedback from lots of people in this office, that they need to be able to talk to their agent or their client about all the different aspects of the contract in a way that they are comfortable with. So communication is the big thing here.
And I'm going to give the standard managing broker answer too. Obviously, what you should be doing is discuss the different options with your buyer or seller and say, you know, these are the different options. What do you want to do? These are the pros and cons, and then let them tell you. And if so Ian, in your case, if they're telling you, we want to win, this seems too complicated, or if you're worried and you give them that option, you say, look, some agents may find that this is too lengthy. Other agents might appreciate it. What do you want to do? And if they say, let's make it, you know, short and sweet, then you have that conversation, get it in writing to cover your ass, and then you go ahead and submit the offer with less subjects. You can do that. I just was hoping before we all leave, if one person from each office, so someone, maybe Ina from the North Van office, someone from the Whistler office, and someone from the East Van office, can just go into web forms, start creating a transaction, and just tell me if the template shows up there. I put it as a Stillhaven condo contract template. Because and I'll make a few changes that we talked about, but essentially, rather than you having to create this from scratch, as the managing broker, I can share contracts with all the offices. So I created this one, and I'll do the same with the detached contracts and the new construction contracts, so that you guys don't have to start this from scratch. And then when you have it, you can take out what you want, reword what you want, but at least the basics of what we just covered, they're all there in the template.
Steve, I was going to add, if I may, recently with some multiple offers that I've had as the listing agent, they've all had subjects, or there's been subjects on the highest offer. And what I've said to my sellers is I like to inquire with the buyer's agent, you know, just how solid the financing is. So as the buyer on the buy side, I like to get permission from my buyers to talk to the agent without giving away personal information, why I think their financing is solid, because I had 3 offers even before COVID on a West End condo that all had subjects, all 3 offers, and then we had to kind of negotiate back and forth and get an offer to come up, and we didn't take the highest offer because their financing didn't seem as solid as the second place offer.
Right. Okay. Gavin is saying the Stillhaven template worked for me. Okay, can anyone from Whistler, or just because we've had issues with web forms not syncing with all the offices. So Maria, okay, perfect, thanks. So it's there, and anyone from Whistler able to verify? You can always let me know later. Okay, so I know that works. So we'll do that with the other contracts as well, and we'll just keep updating them as new things come about. But hopefully you guys find that helpful, that that the contract is there sort of as a template for you to use whenever you want, and just modify it and save it as your own template if you want. Okay, thanks everybody. And next week it's going to be detached new construction, oil tanks, zoning, permits. Oh my.